हेलो दोस्तों एंड स्वागत है आपका स्लीपी क्लासेस की आज की इस बहुत ही इम्पॉर्टेंट वीडियो में। नाउ व्हेन वी लुक एट आवर इंडियन कॉन्स्टिट्यूशन, वन ऑफ द कॉर्नरस्टोन्स ऑफ द कॉन्स्टिट्यूशन इज़ आवर फंडामेंटल राइट्स एंड इनमें से एक बहुत ही ज़रूरी आइडिया है दैट ऑफ राइट टू लिव, राइट, जो कि आर्टिकल 21 के तहत हमें गारंटी किया गया है, राइट। और ये राइट टू लिव जो है एक ह्यूमन लाइफ, राइट, और एक ह्यूमन लाइफ डिग्निटी के बिना नहीं हो सकती है, राइट। डिग्निटी के बिना ऐसी लाइफ इम्पॉसिबल है। एक डिग्निफाइड ह्यूमन लाइफ व्यतीत करने का मौका, एक अधिकार हमें देता है। And that is why, due to a liberal reading of this constitutional provision, added on by a number of judicial readings as well, राइट टू लिव को बहुत ब्रॉडली इंटरप्रेट किया गया है कि सिर्फ एनिमल एग्जिस्टेंस नहीं है, इसके कारण जो है हमारा राइट टू हैव अ डिसेंट स्टैंडर्ड ऑफ लिविंग, राइट टू बी फ्री फ्रॉम हंगर एंड स्टार्वेशन, टू बी एबल टू लिव इन अ पोल्यूशन फ्री एनवायरनमेंट, ये सब ही इससे स्टेम किए हैं। ठीक है, तभी हम बात करते हैं ना कि कितनी ज़्यादा ओपन एंडेड, राइट, हमारी इंडियन कॉन्स्टिट्यूशन के इन प्रोविजंस ने फॉर एन एवर इवॉल्विंग सोसाइटी हमें एक लीगल फिलोसफिकल बेसिस फॉर द स्टडी इम्प्रूवमेंट ऑफ आवर लाइव्स जो है प्रोवाइड किया है ऐसे प्रोविजंस ने। और इसी के तहत एक और इंटरप्रिटेशन जो की आ गई है कि अगर हमें एक डिग्निटी के साथ जीवन व्यतीत करने का अधिकार है, वी हैव द राइट टू लिव आवर लाइफ विद डिग्निटी, then we also possess the right to have a dignified death, right? So a smoothing of process of dying to ensure that one doesn't have to go through torture, that one doesn't have to go through indignity, that one has a dignified end has also been read into this right. Now, apart from Supreme Court rulings, the implementation part, which comes to the executive, wherein a number of state governments are also involved, have now been taking up the challenge of implementing these at their ground levels. Right? Maharashtra government had tried doing the same in 2024 by wanting to implement this right to die with dignity, which was put forth into action through Supreme Court orders, right? पहली बार the idea of right to die with dignity, the ideas of passive euthanasia की बात 2011 में हुई थी, right, during the Aruna Schonbach case, and later on through the 2018 judgments and following 2023 judgments, this has been made even more rigorous. And now the Karnataka government has passed an order to set up medical boards, both primary and secondary, to be able to ensure the implementation of right to die with dignity. Right? So this is exactly what has happened. That the Karnataka government has now ordered that all the hospitals need to set up both primary and secondary boards, which will look at these living wills, right, which will look at the advance directives which have been granted by terminally ill patients or those patients who are going to be in vegetative state with no hope for recovery, so that they can die with dignity as well, right? साथ ही में very importantly, these are the medical boards which will be in charge of looking at the requests that are put in to implement these advanced directives, right? And what does this lead to? This leads to passive euthanasia. When we look at euthanasia as such, euthanasia is a very broad term, right? And usually हम बात करते हैं कि इसकी बहुत सारे categories आते हैं. In all जो है, we say there are 5 types of mercy killings. There can be voluntary mercy killing, non-voluntary, then involuntary, passive and active. However, the most common differentiation जो कि किया जाता है is between your active euthanasia and passive euthanasia. तो जब हम active euthanasia की बात करते हैं, usually active euthanasia का मतलब होता है कि आप you put to death, right? आप जो है actively intervene करते हैं मारने के लिए, right? So you can inject, you can have a lethal injection which is subjected to a patient. So स्विट्ज़रलैंड जैसी कंट्रीज़ के अंदर जो है इस तरह से होता है, राइट। कुछ और भी कंट्रीज़ है, कनाडा, बेल्जियम, लग्जमबर्ग, इनके पास ऑप्शन है ऑफ बोथ active and passive euthanasia, right? On the other hand, passive euthanasia क्या कहता है? Passive euthanasia कहता है that a person won't be able to survive without certain life sustaining therapy, right? So for example, ventilator is the only thing keeping the person alive. So when you withdraw that life sustaining therapy, right, the person will automatically wither away. And what is that called? That is called passive euthanasia. So it is in this realm of passive euthanasia जहाँ पे काफ़ी ज़्यादा काम कर रहा है, जहाँ पे बहुत सारी रूलिंग्स आई हैं सुप्रीम कोर्ट की. Now, as we know, one of the most important cases in this regard has been the Aruna Schoenberg case. Right? So, Aruna Schoenberg, जो कि एक nurse थी, 1973 में she underwent a brutal assault and attack on her, which left her in a vegetative state. और इसी के चलते हुए एक प्ली फाइल की गई बाय पिंकी विरानी, राइट, जहाँ पे उन्होंने बोला कि देखिए अरुणा शॉनबाग जी को जो है बस सस्टेन किया जा रहा है एंड मे बी वी शुड लेट हर डाई विद डिग्निटी, वी शुड लेट हर गो अवे एंड रिमूव वेंटिलेटर सपोर्ट. ठीक है, तो ये जो है इशू चलता आ रहा था. इससे पहले भी 2005 में एक NGO कॉमन कॉज जो है उन्होंने टर्मिनली इल पेशेंट्स के लिए पैसिव यूथनेशिया का जो है डिमांड की थी अंडर आर्टिकल 21. इसी के चलते हुए लॉ कमीशन ने भी 2005 में सजेस्ट किया था ड्राफ्ट बिल ऑन पैसिव यूथनेशिया एंड कहा था दैट सच रिक्वेस्ट कैन बी मेड फॉर द हाई कोर्ट्स विच विल देन टेक इनटू कंसिडरेशन the views of experts, doctors, physicians, etc. before giving in a judgment. Right? So following this, finally, Supreme Court on a separate plea by Aruna Schoenberg started having a conversation about the same. Right? Now what happened that the Supreme Court did recognize passive euthanasia. However, the hospital staff wanted to continue taking care of Aruna Schoenberg. Therefore, in her particular case, passive euthanasia for her wasn't allowed and she only passed away in 2015 due to pneumonia-related complications. However, right after this, another debate started with respect to requirement of these living wills. How are they to be processed? What is going to be the procedure, right? How do we ensure that proper ethics are maintained? And for this, a constitution bench was set up to look into this matter. In 2018, therefore, the common cause judgment came through, which now properly recognized the right to die with dignity as a fundamental right. Right? This is very important. We have right to life as a fundamental right also. We also have now right to die with dignity as a fundamental right under same Article 21. And 2023 की एक और following सुप्रीम कोर्ट की कॉन्स्टिट्यूशनल जजमेंट ने ही फर्दर कुछ चेंजेस किए टू इट्स 2018 जजमेंट सो एज टू मेक दिस एंटायर प्रोसेस अ लिटिल easier. Now let us quickly delve into this. 2018, a 5-judge bench, basically led by then Chief Justice Deepak Misra, recognized and has given sanction for what? For passive euthanasia, right? And they said what? That under Article 21, the very right to life is inclusive of right to die with dignity. That one has to make as easy as possible the process of dying for a terminally ill patient or for a person who's in a vegetative state, right? Vegetative state क्या होता है? That they can't really do anything on their own, right? They are just breathing through a life-sustaining support, right? And there's no hope for recovery at all. Now, in doing so, the court made an active distinction between active and passive euthanasia, right? So within the 2018 judgment itself, this was provided for. And what did the Supreme Court say? The Supreme Court said that when it comes to active euthanasia, a specific overt act, right? Some action is done which puts an end to the patient's life. So you have to actively intervene to end their life, right? So even if you're removing certain support, etc., the person will continue living, right? However, say bad their condition may be, right? So sometimes, you know, you've had numerous movies, etc., also that have come out, right? Movies of various kinds wherein they have talked about this issue, right? Wherein you know, people say who who are in a certain position, who are, say, in a state of paralysis, which really, really impacts their life, and that is something that they're not comfortable with, choosing to go down this route, or people who are very aged, wanting to die in a certain way, in a certain manner, choosing to actively end their life, right? So through lethal injections, etc., that was active euthanasia. However, in passive euthanasia, you aren't doing something to kill them. Instead, you basically end up not doing something which is necessary to keep them alive, right? That they're only alive through outside support, and you take that outside support out of the picture, which automatically leads to the death of the patient, right? For example, taking out the ventilator. Now, all of this was dependent on an advance directive, or what is called a living will, right? So basically, what is this? This means that a person who's terminally ill, or who's going through a deteriorating health, or even before that, can decide, when that person is in proper state of mind, to execute, to come up with a certain living will. And what does the document state? The document states in advance that so and so person, right, chooses not to remain in a vegetative state with life support, right? So they already declare this, that listen, if things come to this, I do not want to be kept alive forcefully through a ventilator in a vegetative state. I want to die with dignity. I don't want to go through this pain, right? So therefore, in advance, they can express their wishes to implement the same if they happen to enter a stage wherein they are terminally ill, or whether they're in a vegetative state, and then they cannot say or emote their specific decision. This document is then presented to the hospital, wherein appropriate action can then be taken in case they do understand that yes, that the patient is terminally ill, or they won't recover, and therefore in accordance to their wishes, the same can be undertaken. Now, in 2023, the guidelines which were put in place by the 2018 judgment, in 2023, another 5-judge bench came under former Justice K.M. Joseph, right? And they decided to simplify the procedure even more. Now, the first thing that they did was that they did away with the role of the judicial magistrate first class, wherein now for the willing will to have validity, early on after the 2018 judgment, the JMFC had to give sanction and validity to the living will, which could then be executed. Now, what did the 2023 order said? That basically whatever living will or advance directive that you made, it doesn't have to be sanctioned by the JMFC. It just needs to be attested by a notary or any gazetted officer, right? So that they can satisfy that yes, this living will was made willingly, voluntarily. Nobody was forcing them to make the same. Furthermore, the authorization of advance directives or the living wills which are made can now be made, right? It can now be granted by one among multiple guardians or close relatives. So early on, what used to happen, that only one person was put in charge. Say a person says, my wife will decide, or my son will decide, or my daughter will decide. Right? Now the thing is that sometimes that person may also not be in a state to make a decision. Or what happens that if both of you are put in that condition, right? What if there is an accident and you are in a vegetative state, and your wife, who was put in charge only and who is the sole decision maker, say passes away, or is herself in that state, then what happens, right? So now they say that there can be multiple guardians or close relatives, and any one amongst them can take this decision. Very importantly, whatever living will or this advance directive is made, now the district court or the JMFC does not need to preserve copies. Only whatever concerned local body there is. It can be, say, a municipal corporation, a panchayati body, they have to preserve a copy of this living will, right? Now, very importantly, instead of the judicial magistrate, the executor, the person who's been given charge, will hand over the documents of this living will to the family physician, whoever the doctor in charge is, apart from the guardians and the relatives, right? So executor will come. Now you don't have to wait for the judicial magistrate. उनके पास इतना काम होता है कि वो बिजी होते हैं, वो नहीं निकाल पाते, तो जो एग्जीक्यूटर आएंगे वो कॉपीज देंगे गार्डियंस को, रिलेटिव्स को, एंड जो डॉक्टर इन चार्ज है उनको भी कॉपी मिलेगी, राइट? जो एग्जीक्यूटर है वो साथ ही में जो एग्जीक्यूटर है वो क्या करेंगे, अपना जो डिजिटल हेल्थ रिकॉर्ड है उसका भी हिस्सा बना सकते हैं, राइट। तो हमारे पास अब फैसिलिटीज़ है, तो उससे क्या होता है, एक ही टैब पे आप सब कुछ एक्सेस कर सकते हो और आपकी लिविंग बिल भी वहीं पे होगी, राइट। नाउ व्हेन इट कम्स टू एग्जीक्यूटिंग द डायरेक्टिव, इसको इवैल्यूएट एंड इनिशिएट किया जाएगा बाय द डॉक्टर once the patient loses decision making कैपेसिटीज, राइट। सो व्हाट हैपन्स कि या तो डिजिटल रिकॉर्ड में है या एग्जीक्यूटर के पास से ये जो है एडवांस विल मिल गई, जो गार्डियंस को दे दी गई है, जो डॉक्टर को दे दी गई है। अब डॉक्टर क्या बोलेगा, ओके नाउ दे हैव एंटर्ड अ स्टेट जहाँ पे वो डिसीजन मेकिंग नहीं कर सकते हैं, राइट, जो एकदम वेजिटेटिव स्टेट पे आ गए हैं, राइट। दे हैव लॉस्ट कंट्रोल ऑफ बीइंग एबल टू मेक रैशनल डिसीजंस में भी, ठीक है। तो उस दौरान जो है फिजिशियन इसको इनिशिएट कर सकता है। ना वेरी इंपॉर्टेंटली प्राइमरी मेडिकल बोर्ड जो है सेटअप किया जाता है ये देखने के लिए कि क्या हमें अलाउ करना चाहिए पैसिव यूथनेशिया को, ये राइट टू डाई विद डिग्निटी को या नहीं। Now in this scenario in 2023 the minimum number of specialist doctors which were required in the primary medical board to act on the physical physician's evaluation have now been reduced from 3 specialists to 2 specialists who should have at least 5 years experience, right, who will take a call on whatever suggestion has been given by the doctor in charge within 48 hours of such referral, that yes we will allow them the right to dignity or the right to die or not. In the event that the primary board does agree that yes the advance directive has to be acted upon, that yes right to die is being allowed, in that scenario to keep a secondary check, a secondary medical board rather than district collector. Early on in 2018 it used to be the district collector, right, but that was making the process cumbersome without expertise. Now a secondary medical board jo hai that will be set up, that will provide its opinion within another 48 hours, right. And here the secondary board, if the executor is still in a position to be able to communicate in some way or the other, right, can ascertain the wishes that yes do you want to die, do you want to be taken, do you want this life sustaining therapy to be taken away from you, right. If it is possible they will try doing that. In the event that the person or the executor is incapable of making any such decisions, right, then what happens, the consent of the person or persons nominated by the executors, right, they can be certain siblings, children, partner, right, their permission will be taken to carry forward the advance directive. Now the hospital where the patient is admitted will convey this decision of both the primary and the secondary medical boards as well as the consent of the persons named in the advanced directive, right. So the primary and secondary board say they agree to let them remove the life sustaining therapy, and the guardians also agree. This decision will be conveyed to the judicial magistrate and then the decision will be implemented to withdraw the medical treatment which was being administered to the executors. Now what happens in case there is some disagreement, right? What do you do then? Now if primary medical board takes a decision that we are not going to follow the advance directive, we are not going to allow this right to die with dignity, in that scenario also the guardians who were left in charge can request that particular hospital to refer the case to the secondary medical board, that can you please consider this and make a decision whether the living will is to be implemented or not. Now what happens in case this request is denied by the secondary medical board? In this scenario the nominees can then approach the High Court under Article 226, and the High Court can then take a call whether the same can be implemented or not, right. So now there is a proper process in place. Where do you go in case of grievances, right? Where do you go in case you disagree, right? That has also been put out, right. Now again various states are trying to implement this. However, we have seen that both taking this decision and not taking it can be very difficult. In fact, apart from medical validity and the medical expertise required, there is also the idea of ethics. And यहाँ पे 4 broad ethical pillars जिनका ध्यान रखना चाहिए उन्हें point out किया गया है. The first is the idea of beneficence, right? Which says what? That basically beneficence needs to come from the doctor and the bench. Say in case you go to the High Court, the bench in charge, they should be looking to ensure the patient's benefit. That should be the main idea. Not your own morality, not social morality, not what log kahenge, but whether it benefits patient or not. Whether it puts them out of pain, it puts them out of misery, you have to consider all of that. Second, non-maleficence means that the decision maker has to ensure that he is not intending to harm the patient. Third is the idea of justice, that the right of the patients should not be exploited. Right? Sometimes what happens, just to be able to make more money out of keeping them, let's just keep them there. Right? Just prolong their stay, let's just prolong their life. So the rights of the patient should not be exploited. And last but not the least, the very idea of autonomy, which allows us as free willing humans the decision, the right to choose how we want to go, when we want to end their lives. Right? This is something which should be allowed to us. However, again, this doesn't simplify the matter. It's still very complicated. पहली चीज़ तो even though living will को advance directive have been given a legal basis, not a lot of people have made these. Why? Because of the cultural mores in the society, wherein talking about death or even making forget a living will, making a will in advance is also considered a taboo that is going to bring you bad luck, that you're thinking about death. Right? तो making a living will कि अगर मैं ऐसी condition में आ गई या आ गया, that is to considered a huge taboo in the society. Right? Which is why it hasn't really been able to take off in India also. Right? Then very importantly, there is also the issue of lack of clarity in passive euthanasia. Right? And what do you understand by withdrawal of life sustaining methods? Right? In 2024, there was this case wherein a 30-year-old person who was in a permanent vegetative state, right, his aging parents approached the court to allow right to die, right, to be able to die with dignity by removal of life sustaining therapy. Now here there was the question of something called Ryle's tube. Right? Ryle's tube क्या होती है? Basically, it provides food via nose to the stomach. And the court opined that Ryle's tube does not equal life-sustaining therapy. And therefore, we cannot allow the same. Right? So they say that a lot of times the decision taken by medical boards or bench, they are also intimidated a lot by the public opinion. The public opinion does not treat this as freeing the person, right, allowing them to escape pain, but sometimes looks at it as murder because of the cultural rules surrounding death in India. Right? Therefore, it is high time that one looks at the issue of right to die as a constitutional issue, as an issue pertaining to the rights of the person, right, as pertaining to right to live and die with dignity, and also the difference between euthanasia and withdrawal of life-sustaining interventions needs to be made more clear. Right? So you involve medical experts, you involve ethical experts, you tell us what constitutes as life-sustaining methods and what does not, so that a more active and proper decision can be made with respect to the same without any confusion. Right? So you must remember all of these issues, very important from prelims perspective, from optional perspective, from ethics perspective in GS also. Right? All of these issues will help you in all these arenas. So आपने इनको याद रखना है. आपका क्या कहना है अबाउट राइट टू डाई विद डिग्निटी? किस तरह से जो है इसे और easily implement किया जाए so as to ensure benefit and rights of the patients also, and to prevent any sort of exploitation as well.